Just like the old days when we had the wars and had warriors, we now have warriors that go forward in the courts and in the Congress to resolve these conflicts. And the lawyers at the Native American Rights Fund are glad to be those modern-day Indian warriors. There was an era of change for Indian country. It was the Indian people stepping up themselves, calling the federal government on the carpet for the mistakes they made.
The civil rights movement was just coming into Indian country, and really at the inception of the modern era of federal Indian law. And we bent some rules back there to become the Native American Rights Fund, and jumping into these important cases to facilitate that great social movement back then.
In an era that raised voices against the war in Vietnam and demanded civil rights for all Americans, the very existence for Indian tribes in the United States was at stake.
We'd been laboring under this termination policy that we all knew was wrong. We wanted to stop that and reverse it. The way to do that was to rely on our treaties.
The 1950s termination policies by the federal government had taken effect in an effort to once again assimilate the Indian. By the mid-1960s, as many as 109 tribes, rich in natural resources, had been stripped of their land titles. Their right to self-govern as sovereign Indian nations had been lost.
There was, I think, a widespread view that the Indian treaties were just ancient history, documents that weren't relevant anymore because the policy of the federal government was to terminate our tribes, eliminate our tribes, and the future of our people was assimilation.
The Menominee tribe of Wisconsin was first to be terminated in 1954.
And the Menomonee Restoration Act and that whole reversal of the termination policy, I think it's one of the most significant things that NARF has done in its history. Menomonee has a beautiful reservation in Wisconsin, timber cutting, timber harvesting, and they were doing pretty well as a tribe. As soon as they were terminated, their lands were taken out of trust, and they began losing land from their reservation to non-Indians, and it was being sold to build homes and such, and destroying some of the timberland and that sort of thing. And they became quite concerned about the future of the tribe under termination.
Termination was a cultural, economic, political disaster. Our tribal rolls were closed, our tribal government was abolished, our lands became subject to taxation. We were no longer a federally recognized Indian tribe.
And that meant that for all practical purposes, Menominee sovereignty was gone. Sovereignty, the ability to govern yourselves, to have self-determination, to make your own decisions, all that was taken away.
Menominee was determined to fight back. To do that, it would mean convincing Congress to reverse their terminated status and restore them as a federally recognized tribe.
But the problem was we didn't really have very many lawyers. Lawyers cost money. Most of our people were poor. We needed to get innovative.
The poor live in a descending spiral, while all around them the economy goes up and up.
In the late 1960s, as a part of the federal government's War on Poverty initiative, public legal service programs were established to represent some of the country's poorest Americans.
We believe the time has now arrived for the Indian to use his own initiative to take charge of his own destiny.
For Indian country, the initial response came with the establishment of the organization, California Indian Legal Services, or CILS, based in Berkeley. With funding from the Ford Foundation, the Native American Rights Fund started as a project of CILS in 1970 and soon moved its headquarters to Boulder, Colorado.
We wanted to choose cases that would have a nationwide impact on the rights of Indian people.
The same year the Native American Rights Fund would take on its first case in representing the Menominees, President Nixon was advancing a national policy of self-determination for Indian tribes. Many saw this as the beginning of the end to termination.
This will mark one of those periods in American history where after a very, very long time, and at times a very sad history of injustice, that we started on a new road which led us to justice in the treatment of those who were the first Americans.
To earmark this change in government policies, Nixon signed a historic bill that returned nearly 50,000 acres of the Carson National Forest, which also holds the sacred Blue Lake, back to the Taos Pueblo Indians. 3 years later, Nixon would sign the Menominee Restoration Act into law on December 22, 1973.
We achieved a very historic victory in 1973. I knew that it was important, but I didn't have the perspective at that point that I knew also that it would be a precedent.
And it did set a precedent that has been honored by Congress. And it was a great moment, and it signaled finally that the termination era was over. That year, in 1973, at the NCAI annual convention, the slogan was, "Restoration Now." And so Indian country meant it.
That Menominee Restoration Act, I think, really showed everybody that, yes, it could be done, and Congress could do the right thing for a change.
The Menominee Restoration Act set the stage for other terminated tribes to be restored. It also set in motion a series of new battles to fight in the protection of tribal natural resources.
When we go out and talk to all these citizens of America, we tell them, you better do something about your government.
In the Pacific Northwest, along the Nisqually River, a fish war was surfacing at a violent pace.
I went to jail hundreds of times, not only me, but our other people that's fighting the fight.
Regional tribes, clashing with the state of Washington, were fighting for their right to harvest and fish the sacred salmon that for centuries had become critical to their cultural and economic livelihood.
We have this fishing right. It's a treaty supreme law of the land under their constitution, and we're not going to give up our fishing rights.
The state of Washington responded in military style.
But in those days, there wasn't a lot of Indian law that was presented in court. NARF was one of the main ones that came forward and started to put the plan together with us.
The Native American Rights Fund served as lead counsel in the federal district court trial that would change history. On February 12, 1974, Judge George Bolt ruled in favor of Indian fishermen and an 1855 treaty that guaranteed tribes the right to harvest their traditional fishing sites.
Judge Bolt listened to our people, our elders, and they were the people that told the stories of who we are. And Indian law was what it was all about, you know, our culture and our way of life, and the understanding that Judge Bolt gave it.
By the end of the 1970s, the Menominee Restoration Act and the Bolt decision had set the sovereignty movement in full swing, with tribes finally solidifying their presence in the cultural and political landscape. The modern era of federal Indian law had begun.
It seemed as though we couldn't lose a case back in the 70s. NARF continued to be at the forefront in the 1980s.
By 1984, NARF established its second satellite office in Anchorage, Alaska. The first branch office was incorporated in Washington, D.C. in 1971. In the future, both will prove critical in pursuing the mission of the organization to preserve and enforce the status of tribes as sovereign governing bodies.
The challenges became greater, the issues became more complex, and the treaty victories and the political victories, you know, in Congress generated anti-Indian sentiments, and just a warning signal that our people have to be ever vigilant to protect our victories and our wins.
The appointment of the conservative Reagan administration in the 1980s began to weaken Indian law and policy. Impact litigation on the promotion of human rights involving religious freedoms, sacred sites protection, and the repatriation of burial remains suddenly became more difficult to address in the courts. The shift in attitudes would mean a shift in strategy for NARF, taking the issues from the judicial to the legislative arena.
So when the courts were turning sour on us, we were in the Congress at that time. And then again, very exciting.
In the course of this year, Senator, I wish you would find out why the law is so rigorously enforced on Indians who use eagle feathers for religious purposes.
The leadership of the senators and the experienced Indian law staff, political staff of the Select Committee at that time churned out very impressive and inspirational array of laws.
Today here in Washington, the Smithsonian Institution agreed to return the bones of about 19,000 American Indians to their tribes.
NARF was a lead advocate of the Native American Graves Protection and Repatriation Act, or Nagpra, which President Bush signed into law on November 23, 1990. To this day, Nagpra has been considered some of the most important human rights legislation ever passed for Indians in returning ancestral remains and objects back to the tribes. Meanwhile, the largest legal battle NARF, along with private co-counsel, would file was coming to the fore, involving billions of dollars owed to individual Indian landowners by the federal government delinquent on payments dating as far back as the late 19th century.
It's an accounting's claim. Early on in the 1800s, the United States forcibly imposed these accounts onto tribal members and tribes, where you might receive proceeds from maybe a grazing lease or oil and gas royalties. The United States, as a unilateral trustee, has never provided an accounting for those accounts.
In 1996, Blackfeet banker Eloise Cobell would approach NARF to take on this behemoth case, pitting 500,000 Indian landowners against the Department of Interior's Bureau of Indian Affairs.
I am here today on behalf of the more than 500,000 individual Indian trust beneficiaries.
There's billions of dollars at stake. It's something that had to be done because we were never ever going to be able to resolve that politically, and even though it was the biggest case in Indian history ever filed, somebody had to do it, and if we didn't do it at the Native American Rights Fund, nobody would do it.
The Native American Rights Fund recently filed Nez Perce versus Kempthorne, a similar suit but on behalf of tribes, not individuals, who also allege mismanaged trust accounting over the years. On the horizon of the 21st century, NARF is poised to take on a series of new challenges that will not only impact Indian country, but perhaps the greater global community. As talks of climate change heat up, the Native American Rights Fund is focused on Kivalina, Alaska, an eroding strip of land that scientists predict will be swallowed by the Chukchi Sea within the next decade.
Their community is being washed into the sea, literally. Yet this community has contributed, such a minimum amount of emissions. Do we have a responsibility to this community and other communities? Well, we believe, yes, there is a responsibility. And therefore, there has to be some kind of legal remedy for being able to shift the burden, the financial burden, over to the emitters.
NARF's Alaska team of attorneys are investigating ways to keep Kivalina intact as a tribal village, even if it means relocating its 400 members to a nearby spit of land. The biggest threat facing the tribe is that they will be forced to move far from their indigenous territory, separated from their traditional communal and subsistence way of life.
If our focus, if our mission is to help protect and preserve the Native way of life, what can we do to prepare government to respond to the needs of Native people? What can we do to empower the tribal voices?
NARF Alaska fought and won for the protection of subsistence living in the landmark Katie John case in the 1980s. That victory will no doubt be critical in supporting the future development of the NARF Global Warming Project. As the Native American Rights Fund embraces the challenges of a new era, aggressive education initiatives have emerged as well. Among them has been the establishment of the Supreme Court Project in 2001. The Tribal Supreme Court Project, a joint initiative of NARF and the National Congress of American Indians, is designed to directly address the increasingly conservative federal bench and the ongoing defeat Indian cases have been dealt in the High Court. Meanwhile, NARF continues to provide public access to its comprehensive National Indian Law Library housed at NARF headquarters in Boulder, Colorado.
We still have many needs in Indian country. The biggest challenge we have right now is trying to overcome gaming. They think all of the tribes are rich off at the casinos, all the tribal members are millionaires. Of course, that's far from the truth. Unfortunately, too many of our political leaders, judges, and other public officials think that that's the case.
That's really where I hope NARF can go in the future too, is to start dispelling a lot of these myths and doing a lot of education through the work that we do. And really the work we do here, it's impact litigation. We're building Indian nations, and that's what we do here.
We stand up in Caledonia, manned up at Oka, got sent to Oklahoma and gathered up in Arizona. Big Mountain to Bear Butte, rallied up in South Dakota. Mohawk and Nishinab, Canada to Minnesota. Wounded to California, Kuya Kumiye, Luceño, Hoopa, and all the natives in LA. The Maya Mexica movement in MacArthur Park, May 1st, May Days, and May Lays. So let's start to gather and rally from New York to Cali in resolution, fighting this pollution. Atomic bombs at Yucca Mountain, the rivers are shouting. I'm counting days when all this will change and we stop down. I went from battling on mics to battling for rights, fighting the power for sacred sites. Call me, I wear my culture on my shoulder, my freedom on my sleeve, cause this is for my brothers in the war, best believe. Opportunity to move and make change, feeling it deep inside things we fight for our planes. From the Vatican assassins, Jesuit priests, elitists who feast at the table of the mark of the beast. Talk about freedom and peace and cease to exist as a free human being, cause you cease and assist. I got cousins in prison and cousins in the war. Now tell me, what are we fighting for? My mind is racing with emotion, anticipation, and open to an ocean of movement. Moved by love, but I'm broken. I have the token, one hand to play, you eyed me an ocean. Gave me chills, is this real? You opened the world of devotion. I'm coasting down the boardwalk with my Echo Hawk skateboard, making war with thoughts of you, babe, I'm torn. You're my movement, my desire, you're my wire. You ground me, thank God you found me cause I'm tired. You make my journey worth walking, I listen when you're talking. If you were my girl, creeping wouldn't be an option. But until then, I'm feeling this movement through your appealing ways, and I'm willing to love you more than a million. Hey, yo, we fighting for this love like I'm fighting for a purpose. The most beautiful thing is that you make me nervous. If you ask me what we fighting for to get free, love's worth the fight, but that's only if you ask me. Opportunity to move and make change, feeling it deep inside things we fight for our planes. From the Vatican assassins, Jesuit priests, elitists who feast at the table of the mark of the beast. Talk about freedom and peace and cease to resist as a free human being, because you cease and assist. I got cousins in prison and cousins in the war. Now tell me, what are we fighting for? Opportunity to move and make change, feeling it deep inside things we fight for our planes. From the Vatican assassins, Jesuit priests, elitists who feast at the table of the mark of the beast. Talk about freedom and peace and cease to exist as a free human being, because you cease and assist. I got cousins in prison